My topic is arbitration in MES, a realistic approach. My flow of presentation would be, first I would cover introduction to arbitration, then Indian Arbitration and Conciliation Act 1996, then Indian Contract Act 1872, followed by steps to be taken during the arbitration proceedings. Then I would discuss about the important case laws which can become a turning point during the proceedings and the hearing. And last but not the least, what should we do post arbitration? To begin with my content, first I would talk about an introduction to arbitration. As we all know, arbitration is an alternate dispute resolution mechanism. Recently, few days back, Chief Justice of India N.V. Ramanna, in a conference in Dubai organized by Indian Council of Arbitration, has said that arbitration is the most important mechanism to resolve the dispute in the globalized world. And I too also agree that arbitration in the present scenario is one of the best method not only to reduce the caseload in the court of laws, but also very fast and efficient way to resolve the disputes. Coming to the benefits of arbitration, why the arbitration is so important? In the scenario of international arbitration, where important multinational companies are at stake and they fight between each other, but they do not want their issues to be disclosed and their issues to come to the knowledge of public platform, which can affect their market capital and the clientele. So the arbitration is very important in keeping the confidentiality of the parties. None of the arbitration awards and the judgment goes outside in the public platform unless they are appealed in the court of law. Second is party autonomy. Party can choose their own judges, their own arbitrators. They can choose their own counsels. Third is no application of CPC and code procedures. In the arbitration, there is no strict follow and guidelines to be followed with respect to the code procedures such as affidavit or per se civil procedure code is not strictly applicable. It is not applicable. Third is that we can choose the technical experts. Arbitration in the field of construction arbitration is very important because we can choose the arbitrators as engineers, architects, designers who are technically expert in their respective field. The counsels can also be technical experts. This facility is not available when we approach court of law, because the judges, they are not engineers, so as the lawyers. In the field of arbitration, the parties have full liberty to choose their arbitrators as technical experts as well as the counsels. Freedom to defend own case. The party, they can choose to defend their own case. They can have their in-house counsels. They can themselves fight the arbitration case, which is not available in the court of law. Last but not the least, the awards are final and binding. There are very, very limited and narrow grounds as per section 34 of Arbitration Conciliation Act, which provides you the ground to appeal and to put the prayer to set aside the arbitration award. So in the present scenario, the arbitration awards are almost final and binding. The substantive and procedural laws which govern the arbitration is very important to discuss. In Indian scenario, generally the arbitration is between the two parties who have entered into a contract. So these are the matters pertaining to the Contract Act. So Indian Contract Act 1872 is the basically soul of the entire arbitration procedures. So this is the substantive law. Now the procedural law in India is Indian Arbitration and Conciliation Act 1996. Earlier it was 1940 and now it is 1996. So procedural law tells you that what is the procedure to be followed, how the arbitrator has to be appointed, what to do, what not to do, all these steps and the guidelines. However, substantive law, it talks about the overall philosophy of the contract between the two parties which they have entered into. Now coming to the arbitration agreement in our contract agreements. So the arbitration agreement in our contract agreements is actually governed by condition 70 of 2249. Condition 70 of 2249 talks about that the sole arbitrator appointed has to be an engineer. If the appointed arbitrator is not an engineer, then it becomes a ground for appeal. Second is about the admissibility of the claim. Condition 70 says that all the disputes between the parties for which the decision of CWE or any other person in contract is expressed to be final and binding shall not form the part of claim. So these two statements, one about the appointment of engineer as an arbitrator, and second, the admissibility of the claim on which the final decision of CWE or any other officer such as accepting officer is final and binding, shall not form the part of claim. The last part of the arbitration in the globalized world is that India is party to the New York Convention 1958. This New York Convention is important because in the globalized world, all the countries have ratified this convention, which means that any arbitral award published in any part of the world will become enforceable in India if the location where it is published and India, both of them are part to the New York Convention. It helps in ease of business and also helps in establishing a country in the globalized world.